Hello, and thank you for joining us this morning. We have a great group today and a really great session. Welcome to the Los Angeles Latino Chamber of Commerce Small Business Webinar Series. I am Olivia Rios, Director of Operations and Programs, and I'm excited for today's topic, Employment Laws 2023. And the reason I'm excited is that we want you to be able to be updated with the laws that just came into effect. The Los Angeles Latino Chamber of Commerce has partnered with BBSI to bring you the most current changes in both HR and employment laws. Today's presenters are Marilyn Monarno and Minerva Hernandez at BBSI and our subject matter experts with regards to California HR and employment laws. We are thrilled to have partnered up with BBSI not only for they are a sound company, but their services are top-notch. So to get started, let's just dive in. So Marilyn and Minerva, welcome.
Thank you.
Thank you. Thank you so much for having us. Let me go ahead and share my screen. We've put together a small presentation that we hope you find very informative. If you have any questions, please feel free to ask, as we're going along, and we should be able to answer the majority of your questions. If at any point you feel like, you need some more information, then obviously you will have our contact information, or Olivia will provide you with our contact information, and you can reach out to us at any given time. Just a little house cleaning rules. The contents provided herein is presented as general information only. This is not to be disseminated as legal advice or legal assistance, and it's not all encompassing of every standard regulation or compliance rule. BBSI undertakes no obligation to update the information in this presentation, and no representations are made that the content is error-free. Clients should always consult with legal counsel before making any decisions that may affect their business. So now I'm going to go ahead and hand this over to Marilyn Marrero, who will be able to do the presentation for you guys. And again, if you guys have any questions, raise your hand, and either Olivia or myself will, reach out to you and to make sure that your question is answered.
Good morning, everyone. I hope you guys have your coffee and you're ready for all the craziness in California. Good morning. So the agenda for today I'm going to cover is the minimum wage update and the overview of new major California laws, and then the mandatory retirement plans, which most of us know as CalSavers. So for the minimum wage, I'm going to start off that this one went into effect January 1st. It was supposed to be $15 for all employees. They changed it to $15.50 per hour for all employers, large or small. Is somebody check? Okay. So they have the $15.50 for all employees. Employees with 26 or more employees is the same, and the minimum wage employees for under 25 or more than 25 is still the same. They changed it now to $15.50 for large or small. Once the minimum wage reaches $15 per hour for all businesses, wages could then be increased each year for up to 3.5%. This is the clause that was written into the law that allows for them to continue to increase it annually. Then we have also the local ordinances as well, or city ordinances that also need to be followed up as well. The local minimum wage ordinances are listed here. West Hollywood was added to this list. They have provisions for less than 50 and for over 50 employees as well. Minimum exempt for salary. Don't forget that minimum wage affects salary exempt employees. So white collar professionals, $64,480 per year, no less than the $5,373.33 per month. And then the city ordinances do not affect exempt salaries. So this is the area that often gets overlooked. So to be exempt, an employee must pass the duties test and the 2 times the minimum wage test. Always safest to pay hourly.
Very important.
Yep. And then so I'm going to get into the major employment laws for 2023. California Legislature. So every year in October, the governor signs new bills that usually become law on January 1st of the new year. Sometimes these laws get passed for years in the future, like 2024 and 2025. And the governor passed over 85% of the bills that reached his desk. According to the Office of the Governor, 1,166 bills reached the governor's desk, 997 bills signed, and 169 of those bills were vetoed. And then AB 152, California Supplemental Sick Leave. AB 152 expired, so this is very good news for most, if not all, employers. It expired December 31st. It was effective 9/29 of 2022 until the end of the year. The local ordinances remain in effect. So Long Beach, 500 or more employees. The city of Los Angeles, 500 or more employees, and unincorporated areas of LA County, 500 or more employees, and then Oakland, 50 employees or more. Will it come back? You know, we don't know. Last year, the governor signed SB 114 in February of 2022, and that covered 1/1 of until September 30th. So they may or may not. Yep. And the AB 1041, the California Family Rights Act update, expands CFRA to include a designated person in the definition of a family member. And what does a designated person mean? It's defined as an individual, relative by blood or whole association with the employee is the equivalent of a family member. Designated person may be identified by the employee at the time the employee requested leave. So current definition states to care for a child, parent, grandparent, grandchild, sibling, spouse, registered domestic partner, parent-in-law, and now it is a designated person as well. AB 1041 is the California Family Rights Act update. It expands CFRA leave for a serious health condition to care for a designated person as well. An employer may limit an employee to one designated person per a 12-month period for family care and medical leave. An employer may request, an employer may request certification supporting documents to be able to accommodate for this leave. Certification has always been available for employers to request as well. AB 1041, paid sick leave. This one expands sick leave to include a designated person and the definition of a family member. Designated person defined as a person identified by the employee at the time the employee requests paid sick days. An employer may limit an employee to one designated person per 12-month period for paid sick leaves.
I think we might have some questions. Olivia, can you please look into the chat? I believe we have some questions in there.
I did respond to those already.
Oh, okay, perfect.
Yeah.
So
They were just
AB
asking if the session was being recorded, that's all.
Oh, okay.
Okay.
Thank you for that.
So AB 1949 is bereavement leave. This applies to all private employers with 5 or more employees. It provides for 5 days of bereavement leave upon death of a family member, child, parent, sibling, grandparent, grandchild, spouse, domestic partner, or parent-in-law. Eligibility is employed for at least 30 days prior to start of leave. No hours worked restrictions. 5 days need to be consecutive, must be completed within 3 months of the date of death of the family member. AB 1949 bereavement leave, unpaid. So you can do this unpaid unless the current policy provides for pay. So if your policy shows that you're going to pay for the 5 days, then they would be paid. Otherwise, this California just allows you to be able to allow them to take the 5 days. They can be unpaid. Employees may use vacation, personal leave, sick leave, or compensatory time off. Employer can request documentation of death of a family member. So the death certificate or a obituary can also be used. This is the fun stuff. AB 2188, cannabis use. It's effective next year, January 1st, 2024. It makes it unlawful to discriminate based on employees' use of cannabis off the job and away from the workplace, or based on a drug screen that finds non-psychoactive cannabis metabolites, which means the THC that is metabolized and stored in the body. Employers are still entitled to conduct pre-employment drug screens that do not screen for the non-psychoactive cannabis metabolites. This does not apply to building and construction trades or for positions that require a federal background investigation or security clearance. Does not preempt state or federal laws requiring testing for controlled substance. Employers can still prohibit on-duty marijuana use and impairment. SB 1162, pay transparency. Employers with 15 or more employees must include in any job posting the pay scale for the position. So applies for the position that may be filled in California, either in person or remote. The requirement of 15 employees requires only one employee working in California. It applies to direct postings by the employer and to the job posting by a third party. Pay scale must appear in the posting itself. New requirements for employers for 15 or more. So the pay transparency, all employers must provide the pay scale for a position to an applicant upon reasonable request, regardless of whether the applicant has completed an initial interview. All employers must provide an employee with the pay scale for the employee's current position upon request, and records must be maintained for 3 years after the end of the employment. Employers with 100 or more employees must disclose race, ethnicity, gender to the California Civil Rights Department within each of the following job categories. We have executive or senior level officials and managers, first or mid-level officials or managers, professionals, technicians, sales workers, administrative support workers, craft workers, operatives, laborers and helpers, and service workers. Reporting changes for 2023, new due date, the second Wednesday of May. Mean and median data. 2 report types, employers must report workers hired through labor contractors. No reporting of non-California employees. Updated portal and graphs generated by certified pay data reports. CalOSHA's COVID-19 non-emergency regulations, effective date February 3rd of 2023 through February 3rd of 2025. It replaces the current ETS, the emergency temporary standards. These regulations apply to most workers in California who are not covered by the aerosol transmissible disease standard, except for work locations with 1 employee who does not have contact with other persons, employees working from home, and employees teleworking from a location of the employee's choice, which is not under CalOSHA. Important employer requirements for ETS that are part of the non-emergency regulations include provide effective COVID-19 hazard prevention training to employees, provide face coverings when required by CDHP and provide respirators upon request, identify COVID-19 health hazards and develop methods to prevent transmission in the workplace, and investigate and respond to COVID-19 cases and certain employees after close contact. Important employer requirements from ETS that are part of the new non-emergency regulations include make testing available at no cost to employees, include to all employees in the exposed group during an outbreak or a major outbreak, notified affected employees of COVID-19 cases in the workplace, and maintain records of COVID-19 cases to immediately report serious illnesses to CalOSHA and to the local health department when required. Important employer regulations about employee deaths, serious injuries, and serious occupational illnesses to CalOSHA, consistent with existing regulations, and employers must make COVID-19 testing available at no cost and during paid time to employees following close contact. Important employers must exclude COVID-19 cases from the workplace until they are no longer an infection risk and implement policies to prevent transmission after close contact. Employers must review CDPH and CalOSHA guidance regarding ventilations, including CDPH and CalOSHA interim guidelines for ventilations, filtration, and air quality in indoor environments. Employers must also develop, implement, and maintain effective methods to prevent COVID-19 transmission by improving the ventilation. Significant changes to the regulation include employers no longer required to maintain a standalone COVID-19 prevention plan, but may address COVID-19 procedures in their written IIPP or in a separate document. New regulations do not require employers to pay employees while they are excluded from work. Employers must now report major outbreaks to CalOSHA. Changes to the definition for indoor aerospaces of 400,000 or fewer cubic feet. Close contact is now defined as sharing the same indoor airspace with a COVID-19 case for a cumulative total of 15 minutes or more over a 24-hour period during the COVID-19 cases infectious period. For indoor airspaces for greater than 400,000 cubic feet, close contact is defined as being within 6 feet of a COVID-19 case for a cumulative total of 15 minutes or more over a 24-hour period, the COVID-19 cases infectious period. Exposed groups was classified to include employer-provided transportation and employees residing within the employer-provided housing that are covered by the COVID-19 prevention standards. New COVID-19 exposure notification requirements modifies and extends exposure notification requirements to January 1, 2024. Notices to local public health agency no longer required for outbreak. Employers may provide a written notice or a work site posting of potential COVID-19 exposures given to all employees at work site premises within 1 business day, and posting must be displayed for 15 days. Notices must include dates the employee or employee of subcontracted employers with a confirmed case of COVID-19 on the worksite premises within the infectious period, location of the exposure, including the department, floor, building, etc., contact information for the employees to receive information regarding the COVID-19 benefits, contact information for employees to receive the cleaning and disinfection plan that the employer is implementing, so the SB 1044, the workers' right in emergencies, makes it unlawful to take or threaten adverse reaction against an employee for refusing to report or leave a workplace due to a reasonable belief that the workplace is unsafe due to an emergency condition. It also makes it unlawful for employers to prevent employees from using their mobile device to seek emergency assistance to the safety of a situation or communicate with the person to verify that their safety in such an emergency condition. An emergency condition is defined to mean either of the following: conditions of a disaster or extreme peril to the safety of persons or property at the workplace or work site caused by a natural force or criminal act. In order to evacuate a workplace, a work site, a worker's home, or a school of the worker's child due to a natural disaster or a criminal act, does not include a health pandemic such as COVID-19. The new law does not apply to the following: a first responder, a disaster service worker, an employee required by law to render aid or remain on the premises in case of an emergency, an employee or contractor of a healthcare facility who provides direct patient care, an employee working on a military base or in a defense industrial base sector, an employee performing essential work for a nuclear reactor or nuclear materials or waste. The new law does not apply to the following: an employee of a company provided utility, communications, energy, or roadside assistance while the employee is actively engaged in or is being called upon to aid in an emergency response. An employee of a licensed residential care facility, an employee of a depository institution, a transportation employee participating directly in emergency evacuations during an active evacuation, and employees whose primary duty include assisting members of the public to evacuate in case of an emergency. AB 257 is the Fast Food Accountability and Standards Recovery Act. Creates a fast food council appointed by the governor to set minimum wages and standards on working hours and the health and safety and welfare of fast food restaurant workers. It applies to fast food restaurants that are part of a chain of 100 or more establishments nationwide. It authorizes the council to set a minimum wage up to $22 per hour in 2023 and may increase each year thereafter. December 30th, 2022, a Superior Court judge puts a temporary hold on the law. Now we're going to talk about the mandatory retirement plans.
Olivia, does anybody have any questions thus far? I don't know. Okay, let's continue on with mandatory plans.
Sorry.
Yeah, if you could share the deck. So that's one of the questions I'll be asking at the end. So
Yes.
will you share, okay. Let me see. Maria Gutierrez had asked, sorry, just joined, are these questions, are these regulations, are they in effect? That was probably in reference to COVID. And then Marilupe asked, besides COVID, is there new requirements that we need to implement? But you were explaining that new implementation about, the requirements reporting to OSHA and the square footage. So did we answer that, Marilupe? Carlos, can you unmute Marilupe? Marilupe, can you unmute yourself? Marilupe? Okay, she's not on. Okay, Olivia, I think we know COVID will stay around for the rest of our lives as a flu. We need to run a business and need to know regulations that matter besides COVID. Not worried about COVID, my microphone's not working. Okay, all right. And that's it for now.
Perfect, thank you.
Great. So I will get into the SB 1126, which is regarding CalSavers. The original law, the SB 1234, passed back in 2016. The new law, SB 1126, expands the definition of private sector employers that have one or more employees and don't maintain or contribute to a tax qualified retirement plan, which is a plan that qualifies for favorable income tax treatment under Internal Revenue Code sections 401A, 401K, 403A, 403B, 408K, and 408P. Payroll deductions, IRA programs that don't provide for automatic enrollment don't qualify. When did participation in the CalSavers program begin? Employers with more than 100 employees must have registered by June 30th, 2020. Employers with more than 50 employees must have registered by June 30th of 2021. And employers with 5 or more employees must register by December 30th, 2022. Employers with 1 or more employees must register by December 31st, 2025. The law excludes a sole proprietorship, self-employed individuals, or other businesses, entities that do not employ any individuals other than the owner of the business. What should you do? Enroll in a state plan by December 31st, 2025, or establish an employer-sponsored retirement plan by December 31st, 2025. Contact your benefits broker or participate in BBSI multi-employer 401k plan and notify CalSavers of your enrollment or exemption via their website. Must notify even if you already have an employer-sponsored plan. And then I'm just showing you what the screens would look like when you enter the Welcome to CalSavers. It allows you to register your account.
Or exempt yourself.
Or exempt yourself, either or.
So remember, if you haven't done so already, for those of you that don't have a retirement plan and have more than 1 employee, we recommend that you actually go onto CalSavers website, or if you have any questions for CalSavers, they're really easy to get in contact with, and make sure that you register yourself, and then that you actually upload your employees so that and give the opportunity for your employees to decide whether they want to start making any contributions or not. If your employees for some reason do not want to make any contributions, you must have them fill out the opt-out form. Usually what happens is when you enroll yourself and your employees into CalSavers, they will receive some type of an access pin or an access code. Even if the employee does not have that access code, you can print out an opt-out form, make sure that you give it to your employees and send that over to CalSavers just so that they know, and they can mark the employee as the employee is opting out and does not want to participate. You must do this in order to comply. So it's not just like you register and you're done. No, you need to make sure that you comply with the whole program and make sure that those employees that are wanting to make contributions are actually being deducted from payroll, and you are submitting the funds directly to CalSavers. And those that don't want to participate and have decided to opt out, that they actually opt out of the program, and you submit that form to CalSavers as well. That's very important. Yes. If you don't do so, you might be fined and you might be entitled to penalties. And so you want to make sure that you avoid that.
All right, there's a couple of questions. What is the link to CalSavers?
Okay, we can send that.
Yeah, we
We
can
can
actually
send
send that
that
link. We can send it to,
Or if you want to drop it in the chat box.
okay, I'll put it in the chat box right now.
And then the next question is, will a simple IRA that automatically deducts from paychecks qualify?
Yes, I believe so.
Yeah.
All right.
Yes.
Next question. My company has a private plan for all Davis-Bacon employees. Do we have to participate as a company to pay for employees that do not earn Davis-Bacon? What is Davis-Bacon?
What is David? Yeah, what is
Yeah.
David's bacon? I'm assuming this is something, it's some type of retirement plan that you guys put together for your own particular company, right?
Let's see. She responded, prevailing wages.
Hmm.
Okay,
Uh,
so are you asking if everybody has to have it, including those that pay prevailing wages? Was that the question?
Let me see. She had issues with her microphone. Maybe Marilupe, can you maybe re-ask the question in the chat box? Yes, that is the question.
Yeah, so even though regardless of prevailing wages or not, you must have some type of a retirement plan in place for your employees. One thing is whatever the employee gets paid in wages, and another thing is whatever contributions they want to make. Now, mind you, if you put together a plan, the mandate does not require employers to have any type of participation or put any type of money into the plan. It would be ideal. But what the mandate states is that every employer must have some type of a retirement plan for their employees. Okay.
Mhm. All right, next question. How can we confirm if we are registered?
They would normally notify you via mail. They'll send you a letter if you've registered. If you
Mhm.
haven't, if you try to register, you go onto the website and register. They might ask you for an access code, and so you need to make sure that you send them the right information so that they send you that access code. Or you can call them directly and find out. If you're a fairly new employer, chances are you might not even be in the system and might not need to participate. But if you've been in business for a few years now, you're probably already under that mandate and should register for CalSavers.
So can they go to CalSavers to verify if they are?
Yes,
And
they
maybe
can.
request a new PIN code, and then that way,
Yes,
why wait for something to come through the mail, snail
Yes.
mail? And then
yes.
that way they could find out right away. All right, then
Yes.
there's another question. We have a plan through John Hancock. Do we still need to fill out and submit form to CalSavers for those not contribution, or I guess those not contributing?
So if you have a retirement plan outside of CalSavers, CalSavers is not requiring that you register with them. What they're saying is if you already have a retirement plan in place and you're mandated to have a retirement plan, you just must notify CalSavers. You need to let them know. So you must contact them and say, hey, I already have a plan through an outside entity, a third party, and that should suffice. So what they'll do is they will notate the system so that they don't continue to send in the event that they're not able to pull or retrieve any information stating that you already have a retirement plan in place.
Okay, so then in this case, how should they proceed? They should also check onto CalSavers and let them know.
Yes, they should.
Mhm,
Yes.
okay. The next question, what if the employees are part-time? Is it 5 full-time employees?
5 full-time employees or 5 full-time, well, it really doesn't even say whether it's full-time or part-time. It's just 5 employees altogether. So if you employ, I think that would only apply when you're talking about sick and the accrual process. But in general, it's just 5 employees, regardless of whether they're part-time or full-time, because even if they're part-time, they have an opportunity to be able to contribute. So nonetheless.
Okay, and I believe that's all for now.
Perfect. Thank you, guys.
I sent it the other day.
Okay, perfect.
You can continue.
So we were done with our presentation, you guys. Thank you so much for having us and allowing BBSI to come in and present you with this information. We know it's a lot of information in a short period of time. And we know, I'm sure, just like us, everybody's tired of hearing about COVID, but unfortunately, as time goes by, COVID is still a subject of importance and of relevance because new things are happening around it. The mandates on, the distancing from one another, depending on the employer size. And so the good thing is that, employers are no longer required to continue to pay COVID pay for their employees, but, still be on the lookout because although we're tired of hearing about COVID, once things change, you want to be up to date with that information. Okay. Olivia, thank you again for having us. It's been a pleasure. It's always great to be able to partner with you guys and provide you guys with key information.
Well, thank you so much. We want to thank you all for attending today's session. It will be repeated tomorrow at 3 o'clock. So if you need a quick review or would like to invite a colleague, you may do so. Just go back to our website and register at lalcc.org/events. And it's for Wednesday, March 15th at 3 to 4 p.m. And Marilyn, thank you again for your presentation. And I know you mentioned that this deck will be available to share. And let me see if I had one. I think you answered my questions. For retirement plans, go to CalSavers website. Yep. So if this is for employees only, can consultants not participate in CalSavers or they have to do their own?
They're excluded from the CalSavers. Yeah,
okay.
Yeah.
All righty. And then if anyone doesn't have any other questions, before we wrap up, I'd like to share some opportunities we have at the chamber. So we have a couple grants. I don't know if you've been reading our newsletter, but right now Verizon Small Business Grants is open and it closes on May 12th. It is for small businesses to get online courses, do networking, receive expert coaching, and there's grant opportunities. LA County Business Grant Phase 2 is now open and it closes on May 20th. The grant sizes are $15,000 to $20,000 for small businesses with gross revenue of under $2 million. And I think that applies. I could confirm that I have applied. I helped a business apply because there was a language barrier, but it's fairly easy and there's not that much requirements, but it is a vetting process. And they will let you know once you fill out the application. Our signature program, Faces of Resilience, which is taking place on March 24th, is a member-only event, and that event has been sold out. And in May, we have an exciting program with the Department of General Services. It's a 3-part series. Part 1 is how to do business with the state of California. Part 2 is I'm certified, now what? Part 3 is contracting with the state of California. And speaking of contracting with the state of California, we are preparing for our next certification class, which will be taking place in May. So sometime in this second quarter. And, if you are interested and you're not doing contracts with the state, please let us know. It is free for members of the chamber. So that's one of the perks of being a member with the LA Latino Chamber, is that your certification is covered and is inclusive in your general membership. So for now, I leave you. It's 9:40 and I want to thank you for spending your morning with us. If you have any questions, you can email us at info@lalcc.org. Take care. Bye-bye.